The only mentally challenged one here.
Ooh, baby. Morning's here again. So let's do this, sugar. And no cream. Wake up slow, take that first sip. Shizzy's got 'em slipping, losing their grip. His moves so smooth to start your day. What you gonna do? Oh, you know the way. You know Papa don't flinch, don't blink. Ooh, baby, he's sharper than you think. Morning Whiz, take it in. Shizzy's got a whole new spin. Fools keep falling, truth's on fire. Papa Nut just lit the pyre. Oh no, they tried to come for him. Look at those fools looking so dim. They poke, they scratch, they beg, they plead. But I'm right here, waiting for my daddy to lead. Pour it black, shake off the night. Shizzy's teasing, get me going just right. Morning Whiz, start the show. Sip it slow, let it flow. Fools are crying, game's been set. Ooh, baby, they ain't seen nothing yet. Now that's a morning sugar. Coffee's hot and burning. And Shizzy Daddy, oh, he's just getting started. Come on, Daddy, give me some of that something.
Oh my God, Shizzy breaks Larry. Shizzy broke Larry. It's ridiculous. Outro show.
Good morning, everybody. Man, it fires up even on a Tuesday. You guys are so good. You guys are so good to me. I don't deserve you. What a day. What a day. So last night, Mo and I were going over the Shrilla stuff. And oh my gosh, like she's just like, these women, like, please, girls, don't be this way. I mean, all I could see in his, every time that I read this, I could see Lips acting this way towards Chips, man. That's like, oof, it's so bad. It really is so bad how horrible that this person is. I mean, just the attitude towards her boyfriend, supposed to be the love of her life, and just running him in the dirt. I was like, wow. I mean, even Mo is just like, I mean, girls, don't be this way. Oh, but tonight I'll be over and Mo's, and we'll be going over some more of those, plus probably some extra stuff. I mean, Mo puts on a good show. One of my favorites to do streams with. I mean, she's been, her and I have been doing streams together for close to 2 years now. I mean, it doesn't even seem like that. I ran into Mo back whenever we were covering something else with Baker, and it was just like, man, it would just she's just so much fun. And you know, these folks, oh gosh, I can't even begin. You've got this whole anti-Hales group that just really just spits and stutters and freaks the ever living hell out. And oh my gosh, they're just they're not gonna stop. and you know, I don't know how you guys feel about a lot of this, but I find it quite humorous. I mean, just the amount of the mental midgetry that you have to get to on a lot of this stuff. You know, the bad behavior, and we'll go over a little bit of some of that later. I managed to assemble some screenshots last night from Megan and Tons. And oh my God, those letters are insane. They're just absolutely like the letter to the judge. Oh my God. It is like, really? Are you this bad? Mo can really deliver the best one-liners. I know. she absolutely does. Yeah, Ma, it keeps getting deeper and deeper. Hey, Jared, good to see you. Good morning. Oh my gosh, it's. I don't know the way that you would describe it other than unhinged. Like all of the stuff that I've been seeing coming out of them is the most unhinged stuff. Just like where do these people come from? I mean, and you say, well, it must just only be in Florida. No. You get them from New York too. I mean, or Jersey or wherever the hell their law degrees might come from, and then get stripped away from them, of course. And you know, those prison convictions tend to really put a slap down on. I mean, imagine going through however many years of college, passing your bar, you know, and then just to throw it all away. And that to me is one of the most pitiful portions of their existence. Is like you had all of the ability to do something really good, and instead of, you know, doing something good or doing something bad, I mean, that probably would have been better than the horrible crap that they've done. Like even bad lawyers know better than to do half the crap that they've done. But, you know, alas, here we are, you know, in 2026, and they still don't seem to get it. They still seem to find, you know, the time and the energy to, you know, just screw themselves over on a regular basis. And, you know, I dug in a little bit yesterday on this one, and it was, hey, I watched So You Don't Have To. Oh, you know what? I need to have you on sometime so we can do a stream, because I enjoy every single bit of your morning. Every time that you do one of those, they are absolutely some of the finest, you know, finest little pieces of not having to watch a stream. And it really has helped me out a lot to be able to come in, pull those up, and gives me like that little injection of, okay, I'm not the only one that's seen the stupidity in all of this. It's great. That's if you guys haven't checked out, I watch So You Don't Have To on Facebook. It is some of the most thrilling stuff, because you're just like how and you just bring so much joy. We appreciate you over here. Oh my gosh. Spawn Trooper, good to see you. Good morning. Ammo girl. It's so much fun. Oh gosh. Yes. And I'm letting all you guys get in here. Oh, all that time, and then wasting it by losing it or quitting because they got their finger caught in the pie. Well, caught in the pie. I got it. Yeah. Oh, Don, that would be a horrible way to put all that time just to throw it away. I know. And I've never understood it. I've never understood that at all. Thrilling. Yes, it is. It really is. It puts a smile on my face. It really does. It's like, I mean, you just don't know. I even took one of your reads and put it into into a song because it was so good. Because it was so much fun. Well, Paint Chips here, of course, filed this, and we talked about this the other day, that he was really upset that the judge is saying, hey, you're not moving forward. And he submits this Rule 72 filing out of necessity because the original 72 rule objections were timely sent to the court by UPS from Southwest Florida, but not apparently docketed after delivering to the Gainesville courthouse. Now, whenever I first looked this over, I was just like, thinking to myself, like, what is the purpose of saying, hey, the court is messed up? Because he is so angry. Like his over alleviated self is so angry that he can't file electronically. That's what it looks like. It just that he's really butthurt that he can't do this electronically, because normally he would be able to paper the court. And the judge won't let him paper the court. And I think the judge realizes this also, that, that's what he wants to do. Strange Little Badger has been here for 4 months of membership. Hello, fellow nutters. Welcome.
Welcome to the shit show.
Yes.
Every single day.
Every single day.
A new flavor of fuckery. Cause everybody's such, you see.
So good to have new members. And my channel keeps growing every day. Thanks to you guys.
Wednesday. And then 4 more days of increasingly stupid, ridiculous, ignorant, boulder, dash, poppycock, bollocks, and
yes.
fuckery.
That is the beautiful thing. I love it. I love it. I'm this makes me so happy to have you guys come in and hey, defendant respectfully submitted this, and then on June 3rd, 2026, defendant mailed those objections and supporting declaration to the courthouse. It got there. He got the tracking. He complains about it being left at the dock, and on June 5th, they called the Gainesville clerk to inquire why the filing had not appeared on the docket. Well, because that's not how it works. Here's the thing. They receive tons of mail. So they're trying to make it sound like there's some conspiracy here. Now, if you've ever had to mail something into the court, it takes time for it to get there. Even if it's next day, it takes some time to get there. Then they have to open it. And once they open it, they have to make sure that they get it to the right place, because there's different dockets that it has to go to. Then they have to scan it in. Then they file it, and it doesn't hit the docket right away. I mean, I know even from doing a filing, just an electronic filing, depends on what time it gets put in there. It could take 24 hours before it actually even hits the docket. I mean, this is not uncommon. Hey, Florida Flipper, friend Psycho, good to see you. So whenever I see this, it's just like, okay, this is cuckoo for Cocoa Puffs. And then he says, assistant clerk who identified herself as Kelly. I mean, you could have put Joan in there, or Julie, or Bobby. It doesn't matter. Had not received the filing. I mean, sure, okay. And further stated she did not recognize anyone named Mueller at the clerk's office, or Mueller, or it could be Miller, or it could have been none of the above. It could have been Mailer. Who knows what it was written on that piece of document? But they seem to want to, bring it up like why hasn't this shown up yet? This creates a serious and troubling discrepancy. They do not ask the court to make a finding of misconduct on the present record. Defendant does not accuse any identified court, employer, carrier of anything, employee, third party, attorney, or third person of wrongdoing at this time. Okay, so what is it that you've got? What have you got? Malnin says, Clark Stark, eat me out. Best comment ever. That killed me. That killed me. Yes, it was Malnin. And thank you for the 20. It was the best comment ever. I thought that was so and it was because spell check. It was the best. It broke Jay. It absolutely broke him. Oh my God. If you haven't seen that stream, what was that, the day before yesterday? I think it was yesterday. It just made me cry. Oh, I was watching that. I think I was may have still been on catch up, trying to get caught up to the to it. And it took a while, but once I got there, it was like, oh my God, that was unbelievable. Now see, all of this for a pro se litigant who cannot file electronically, and there it is. That right there is what he is wanting. He's not wanting to file electronically because if he doesn't have to file electronically, he can paper the court with all kinds of crap. And if you don't believe that that's what they would do, all you have to do is look at the way that Lips is working. This is how she's been operating. She will constantly do this. She will file things over and over and over. And somebody got in my comment section was just like, well, she didn't do this and didn't do. And I'm like, are you this stupid? Like, really, are you this stupid? Don't you see what she's doing? And we'll get into a little bit of that. The behavior that she's exhibiting is that of what you don't want to have clogging up the court. And I tried to explain to them how this works. And all they could come back with is the most ridiculous rhetorical bullshit that is like, who's giving you your speaking points? Are you listening to the fleas? I mean, if you're listening to the fleas, okay, but trying to come in and explain to me how the process works is like, that's not how it works. I mean, you could file these things. Sure. You could file as much garbage as you want to in a court. Does it mean that the court's going to appreciate it and it's not going to make you look unhinged? But this is what he wants to do. He wants to be that pro se litigant who cannot file electronically. And must rely on courthouse intake of paper filings. That's not a minor administrative convenience. It goes directly to access to the court. Timely preservation of rights and confidence that filings delivered to the courthouse actually reach the docket. Again, he's all butthurt because, he's not able to go in there and paper the court. And then of course he talks about, the infiltration of the Northern District of Florida courthouse, its intake channels, its mail route processes, or persons connected to those channels. And Paint Chips is actively collecting evidence regarding that possibility. Now, Paint Chips does not make this statement lightly. He has personal knowledge from his years as a New York lawyer of how vulnerable courthouse adjacent personnel document intake systems can be. Improper influence, bribery, favors, political pressure, intimidation, or outside manipulation. Oh, this is the most ridiculous shit that I have ever seen. Now, Paint Chips also has knowledge of public characterization. Characterization, once attributed to the FBI. That he ran the Italian and Chinese mafias from a strip mall in Staten Island. Is he saying that they accused him of running Italian and Chinese mafias from a strip mall in Staten Island? No, that's not what he was accused of. you have to understand that he claimed he was part of the mafia. Then there was people that would hurt other people if you didn't do what I said. You remember he threatened a disabled elderly man that was blind. That was his disability, or half blind, but legally blind at least. He manipulated him to sign a bunch of documents and run a company, a shell company that was selling scrap metal to China. Now that scrap metal, in case you forget about this, that scrap metal was on top of a bunch of concrete, and they couldn't inspect all of what was down at the bottom of it. Well, then it got to China, and the company that received it in found that they had lined it with junk to boost the weight, to make it seem like there was more metal in there than there actually was. There was some scrap metal, but most of it was filled with, big chunks of concrete and tires and who knows what else at the very bottom of it to give it that appearance of extra weight, because they were buying it by the pound. And whenever they found out, they came back, and part of the Chinese mafia was not too happy about this. There are a little bit of mafiosos there, that are sort of, you scratch my back, I'll scratch yours, and I don't, show up and do some crazy stuff on you. Well, this got wind to the Chinese government. The Chinese government wasn't too happy about it and contacted the State Department. The State Department got involved and started investigating this, and come to find out that they were selling garbage to China, which almost caused a big shipping, trade with China issue, a big no-no. So that's how the feds got involved. And if you think that they didn't do the research on paint chips before they came in and stopped it, there was threats of non-payment. There was all kinds of crap that they were doing. Now, they tried to make good on one of them, saying, oh, our bad, we had no idea what was going on. But yeah, by then, they had gotten involved in it. They started seeing that he was running little shell corporations, and behind all of it was him. I mean, he might have had other people, that were there to be his muscle, like threatening the guy to, blow out his knees and other kinds of crap like that. But hey, paint chips knew what was happening. We've gone over those court documents. You can go back and see the bad behavior of these people. It's not unknown. So him saying that the DOJ's weaponization working group are personally familiar against the backdrop. UPS records showed delivery of this court filing to the Gainesville courthouse, followed by the clerk's office statements that the filing was not received and no Mueller was known to the office. Hales shocking any member of their network or in any courthouse insider committed a specific act of misconduct. He's saying he's not asking the court to find that they did. He has placed the court on notice that in his views, the known facts raise a serious possibility of courthouse infiltration, improper interference, or compromised document handling, and that he is investigating and preserving evidence related to that possibility. You can't investigate your way out of a wet paper bag. You and Volpe. Oh my God, you are the worst investigative reporters. That's what you want to call yourself, that the world has ever fucking seen. You couldn't even figure out who George was. I still don't think they know who George was. I have a feeling that they don't know any of the things. Shizzywhiznut, please identify as a woman and have my baby. Hey, Rats. I don't deserve you. I don't deserve you. Shizzy doesn't he sound stupid? So he throws a bunch of court filings in there. where there is a credible indication that the following delivered at the courthouse did not reach the docket, the appropriate response is not to penalize the pro se litigant who used to recognize carrier and obtain delivery information. You're not being, there's nobody going against you. Like, here's the thing. You filed, I don't know how many documents, and the only response that Randy has given is responding to what needs to be responded to, but you sound completely unhinged. You and Lips got some serious issues. According to the defendant, respectfully request that the court accept this resubmitted Rule 72 timely as filing. Deemed it and June 4, 2026, or at minimum treated as timely resubmission made promptly after defendant learned the clerk's reported non-receipt. Well, reported by whom? Was it Little Dick Fontaine, or was it Little Dick Luthman? Which one was it? Because we know that you're not Big Dick, because that would be your dad. Junior. Loading dock, security, courier, intake, visitor, and internal routing records for any package delivered by UPS at approximately 12:06 and marked as received by Mueller. Or is it Mueller? Mueller. It's like Bueller. Bueller. Defendant also requests any logs, camera footage, blah, 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 blah. It doesn't alter the merits of the objections, but it underscores the need for immediate docket protection. Yes, he wants to file this. Hey, good to see you, Stephen Fard. Long time no see. Yeah. I was waiting for Shizzy to do a new FOIA request on Lyrenet. I feel I'll be mentioned a lot. A FOIA request on the Lipsies. Oh, well, you'll just have to see. I've got some stuff coming up that you guys are going to love. And in case you haven't seen it, over there on the Rumble site, over on Rumble, it's at 122 views. And like I said, I get the next one up to 1,000 views, and the next one goes up, and the next one goes up. Yes, each one of those I have pinned to the top of my stream. If you go over to Rumble and you find Shizzywhiznut, you will find the lawfully obtained body cam footage, and for every 1,000 views on it, I will release the next one, and I will do so for every single one of them. All I have to say is blah, 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 blah. That's right. Oh, this motion is objection under the civil rules of blah, 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 blah. It gives a memorandum of law. So what exactly is he looking for? Like, after he files all of this crap right here at the beginning of it, all he's asking for is to sustain these Rule 72 objections, set aside modified June 2nd order, deem a proposed limited reply attached to Doc 203, and alternatively grant leave to file it. Alternatively, construe Doc 203 as or permitted a short filing comparable to a notice of supplemental authority and supplemental memorandum limited in the statutory versions. And at this point in time, your brain starts shutting down. You're just like, okay, deem this resubmitted rule, alternatively accept this resubmitted rule, direct the CURT to facility personnel, United States Marshal Service, if appropriate, it's not, or any other appropriate court personnel to limit a conduct administrative inquiry into June 4th delivery, marked and delivered, left at the dock and received by Mueller. Direct preservation of all records, logs, manifests, camera footage, loading dock records. Direct the clerk's office to the docket. This resubmission, all supporting exhibits is completed. And with the supplemental material and blah, 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 blah. Preserve the rights and grant other social relief. But this is June 8th. Yeah. But that's not whenever it came in. It was file stamp 6/11/2026. Just because you post date it doesn't change much of anything. Well, the judge had something to say about it. The judge did. He said, overruling the additional objections to the June 2nd order. Now, Paint Chips, he filed these objections 207, and then to the non-dispositive order. on June 2nd, which denied leave to file a reply memorandum. The order of June 11th, 208, overruled the objections. Now, Paint Chips has filed additional objections in 209. They include baseless suggestion. The clerk's office mishandled the original objections. Perhaps the new objections suggest because opposing parties infiltrated the clerk's office, perhaps bribed the clerk's office employees. The assertion is detached from reality. Pretty straightforward. Like nothing here, buddy. And so he says the new objections change nothing. The magistrate's June 2nd order and my June 11th order were correct. It is ordered. The additional objections, 209, are overruled. So order on June 15th, 2026. Just a big no. Simple. But you also have to remember there's a bankruptcy going on. Oh, yeah. You can't forget about that. So, of course, Randy has filed, and this is document 210, in case you're wondering, the status report. Because last time, although he sent it in timely, it took a little while for it to actually load on the docket, and it almost was immediate after the judge said, hey, where's the status report? And Randy was like, it's right there. Now, this is the same document that was filed in Fed 1 as Fed 2. There, he has to, because there's a bankruptcy stay, and the judge has asked him to keep his status update. So as to what's going on with each one of those cases, and he can't just mail it to one. He has to, attach it to both. So basically, the court's ordered July 15th, submit the status report regarding the progress. On the 3rd of 2025, they filed a bankruptcy petition in the United States Bankruptcy Court. On the 15th, the court entered an order staying this case as to the defendant, directed plaintiffs to file a status report every 90 days. Now, on October 21st, the bankruptcy court granted debtor's motion to reinstate case. On January 12th, 2026, a meeting of creditors was held but not concluded. A hearing on the objections to debtor's claim exemptions is scheduled for 210, or was scheduled on 2/10/2026 at 10:30 a.m. Now, the proof of claims were due by 4/2/2026. Now, this is just a good timeline. A final evidentiary hearing on objection to debtor's claim of exemptions regarding homestead is set to be heard on, what do you see, September 15th, 2026 at 1:30 p.m. or as soon thereafter as counsel can be heard at the U.S. Courthouse, 3rd floor, courtroom, Gainesville. The court has set aside 2 hours for this hearing. Plaintiffs will continue to monitor the bankruptcy court proceedings and will file additional status reports as directed by this court. So you got September, October, we've got, what do you, June, July, August, September. So in September, there will be another hearing coming in. Good morning, Squid. Good to see you. I hope you're doing well. And of course, we're gonna have some crazy stuff come up here shortly. And I'm not sure how I want to approach this because it's so unhinged. It is the most asinine shit that I've ever seen. So all of these idiots, and I guess the best way to do this is probably just pull this up for you guys to see what, and just so you can see the amount of unhinged kind of crap that people like to put into my notices here. I guess the best way to put it, that probably would be the best way to show this. Let me see if I've got it here, because it's quite hilarious. And let's see, then no, it would have been from the other day. Let me find it here, because it gave me quite a chuckle when I saw it. I was like, oh, you really are this stupid. Here we go. And it's easier to bring this up. Oh, I know where it came from. It took me a second to realize where this is. And here we go. Let's see if I can zoom in on it a little bit, because you're really going to get a kick out of this. I have to say that whenever I saw this, it gave me such a laugh of the silliness of these people. So as you can see, I posted a couple of days ago, the public record on Leslie Ann Federigos does not stop with her 2025 lawsuit accusing others of harassment. On the later Orange County case tied to that litigation, both Leslie and Michael are named as defendants, right, Michael? The record also shows Michael later withdrew as Leslie's counsel. Leslie is now proceeding pro se. That later case includes claims for malicious prosecution and abusive process. It also includes an amended motion asking the court to declare Leslie Federigos a vexatious litigant, citing a history of prior cases and dismissed filings. Florida bar records also show that Leslie Ann Federigos is permanently retired, not eligible to practice law in Florida, and previously received a public reprimand with conditions. For the full write-up, see my Facebook post. Now, Flawed and Native, the idiot that they are, says June 9th, the judge granted Michael's motion. Shortly after the same day, Leslie filed to adopt her filings. Procedurally correct and saves the court precious time. Randall Shockett, they can't spell Shockett right, in my opinion, abusing the process, objected rather than play his prolonged tactics. Leslie relied facts, not spin. Oh, really? I said, you seem to have missed Leslie's motion to object to Hale's motion to strike. Too hard for you? Oh, they couldn't stop. Oh, no. And then he says, I said, this is Florida's 9th Judicial Circuit. So Florida Rule 2.505 governs counsel's withdrawal. The 2.515 governs signatures. Michael remained counsel of record until the judge authorized his withdrawal. Once Leslie became self-represented, any document she personally filed or presented had to bear her own valid signature to comply with the requirements for an unrepresented party. There's no Florida rule stating that a newly pro se party can file a blanket adoption and automatically cure every defect in a previously submitted papers. Well, they were a little upset with that. Yeah, just a tad bit, And he says, well, Shizzy, I noticed that adoption does exactly that. The document explicitly states that you are representing yourself pro se and you're adopting and ratifying all previous motions, answers, and documents filed in the case by your former attorney. Opposing it, in my opinion, is BS and a waste of the court's precious time. No, opposing it is procedure. Florida allows it. I said, sure it does, but that would still need to be determined by the judge. So she files a motion to adopt. Hales files an objection. Judge rules on it. Is that too hard for you to understand? Well, they were so upset about that they responded and said, you seem to have missed Leslie's motion to object to Hales' motion to strike. Too hard for you? I said, yep, you got me. She's clearly not papering the court. That must be why she keeps filing frivolous papers over and over and over and over again. Totally normal, completely efficient, practically a public service. And no, I did not miss her objection. Filing an objection to a motion to strike does not prove the original filing was proper. It only proves that Leslie filed yet another paper saying she disagrees. A motion is not a ruling. An objection is not a victory. And the judge decides whether the filing stands, not Leslie, and certainly not her Facebook legal support team. How foolish of me not to understand that more filing somehow proves she's not papering the court. Well, they didn't understand because, I had to continue on. And also because using an outdated citation that no longer exists was about as smooth-brained as she could get. And they want to say Florida allows it. Oh, so angry. so angry. They didn't seem to quite understand. They don't seem to quite get that her filing was horrible. I had to go back and look at it because I was just like, something seems odd in all of this. When it, you know, and it goes to her filing. Now, it was interesting to me that, you know, she is completely and utterly unhinged. Well, it's no surprising that she would be completely and utterly unhinged. Let me see if I can get this here for you guys real quick. And I want to double check and make sure that I get that particular one set up for you so you can sort of see what I'm talking about here. Double check and no, that's not it. That's the wrong one. And I want to make sure that I get it. Nope, that's the wrong one. Because I'm an idiot. And I thought I had it pulled up, but of course I don't. Why would I have it pulled up and ready to go? That would make too much sense. Good to see you, friends. Like, let's see. Yes. Let me double check. All right, we've got it here. We've got it here. And I will point it out for you guys because it is something that you would miss unless you were like just doing a simple search on what some of these filings were. And I'll give you a little hint. It's going, well, you have good ones, right? You have a good one. Share screen and we'll pull it up here. Yes, right here. It's this little piece right here. Yeah, rule 1.0 1.80H. And so what I did is I was just like, I wonder what Florida rules. Florida, the rule. 1.80. And I want to make sure I get it right. 1.08, sorry. 1.08. Let's see. 080 and then 080. And then we're going to put it in parentheses. H, and then that one. And I will show you here in a second what it says. Give me a second. Because that one was the one that sort of caught my attention. Because I like to be on top of my game. And here we go. Add to it. Right here. Preparation copies. As you can see, the requirements of the transmittal. The clerk of court, presiding judge, are responsible for sending copies of the signed orders participating parties. Accepted for default party. Service does not need to be provided for parts. Exceptions. Preparation of copies, the court can require one of the attorneys or parties to prepare the proposed final judgment or furnish it to parties beforehand. General context, service, and filing. While it dictates order of transmission, the broader rule covers the general mechanics of civil litigation paperwork. You're currently dealing with a specific case in Florida that would like to proceed. Are you trying to serve an order on a defaulted party? Do you need assistance understand the email service requirements under Rule 2.516? What? Huh? Is this a query related to appellate or family law variation in these rules? Oh, guess what? In case you guys didn't figure out what's going on, She's trying to reuse documents from other filings. And Rule 1.80, or service of orders, a copy of all orders or judgments shall be transmitted to the court, as you can see, bears nothing, no relevance whatsoever in this case, in this jurisdiction, with this court, for this judge. None of it. Absolutely none. Now, me being the smooth brain that I am, the lawyer that I am, well, not. But what in the hell is this mental midget going on about? Yeah. Made a boo-boo, a big boo-boo. Like, this isn't a small error. This is not a small error at all. This is a pretty major error. Like, this is citing law that doesn't exist, statutes that don't exist, statutes that are what they're trying to claim is this one right here that states that the court may act to strike redundant or unnecessary filings. The underlying principle is to avoid duplication, which supports. That's not what the rules say. You just saw what the rules say. It has to do with service. But it did happen to mention that is if it was a query related to an appellate or family law variation in these rules, because those would be completely different. So what she took is she rehashed an old filing that she's probably done somewhere else before, which that rule of civil procedure would be, but it would be for a different courtroom altogether under different rules. But, you know, she's a smart lawyer. Then it took an idiot that doesn't practice law just to do a simple Google search and realize it was completely wrong. Huh. Of course, the smooth brain that wanted to call me out for, you know, she's so smart and I'm simp for her, couldn't even point this out. Couldn't even figure this out. This is the mental midgetry that you have from these people. And they want to claim that they're winning. Well, we know that's not the case. We know that they're not winning. You can see their stupidity on display. Then they don't like it. Oh, no. And it's pretty obvious that they don't like it whenever you can point out their stupidity. It drives them absolutely nuts. Right here, you can see the Honorable Tanya Davis, judge, right here in this case. Oh, by the way, that's today, isn't it? Lips and chips? You're being called stupid. I am stupid. Don't people know this? I mean, imagine if someone as stupid as me can figure this out. Wow. That goes to show your level of intelligence. Imagine that. Calling me stupid. Dumb nuts. Got it. I am the stupidest one here, except for those that are more stupid than me. But that's okay. Writes to the letter, dear Judge Wilson, I write to bring to this court's attention ongoing concerns related to the possible unauthorized filming. The possible unauthorized filming. Well, really? Okay. Of tomorrow's CMC due to the statements of plaintiffs. Due to statements of plaintiffs? What did the plaintiffs state? Okay, I'm thinking, what did Tug and Megan say about this? If I'm not mistaken, they, as far as I know, they may have acknowledged that they had a court hearing coming up, but that's probably about it. At the time that she wrote this on the 15th, I think it was. Yeah, June 15th, right here. It says this was written on the 15th. On the 15th, there was no conversation that was going on that I know of. Matter of fact, I'm pretty sure on the 15th, which would have been Monday. Megan wasn't even online, as far as I know. She was, because she's not there on the weekends. That would have been a Monday that she wrote this to the judge. Pretty sure Megan wasn't there, so how would she have made any statements? Over the past year, plaintiffs have initiated multiple lawsuits, including the present matter. No, wrong again. Because you have to remember that Jeremy has multiple lawsuits. One person has multiple lawsuits. Some of them are in various states of disarray or good places in the process of this. So Jeremy's got lawsuits, but I'm trying to think, how many lawsuits does Tug have? No, pretty sure that's just this one right here. How many is Megan involved in? Oh, wait, let me see. Just one right here. Now, over the past year, there was a lawsuit that Lips brought against Tug, against Jeremy, against Megan, against J-Hib, against myself, which, I didn't even have to lift a finger, and she lost that case. Yeah. Plaintiffs have monetized their YouTube platforms. That's what we do here. Okay. Yeah. There's a thing called monetization. And that's, it's because you want your channel to grow. Something you might want to look at there, Lips, because you had the chance to, have your YouTube monetization turned on. Think about all the thousands of videos that you dropped and tortured everybody with for a few months until, I guess, you got, your meds handled or whatever the hell it was that, got you in place. Something like that. Throughout these proceedings, they have monetized their YouTube platforms by publishing videos, court documents. Yes, and yes. That's what people do on the internet. People that cover court cases, usually you pull up court documents. Unlike the flea that, can't show you any of the receipts, just wants to, yammer their fat jowls and torture us with, especially I watch So You Don't Have To, torture her with absolute, horrible commentary, often accompanied by prejudicial commentary. No, you can't really have prejudicial commentary on, reporting of publicly available court documents, FOIA documents. Yeah, it's not a big deal. Parties, counsels, and evil members of the judiciary. Wait, now, if I remember this right, I don't think that Jeremy has contacted members of the judiciary, unless you're talking about his attorney, because he contacts his attorney, tells his attorney what he would like, and the attorney tells him what he's going to be able to do and what he can't do. That's sort of like the attorney-client kind of thing. We are allowed to talk about court cases constantly, ad nauseum, sometimes sickeningly as much. These YouTubers are not professional reporters or true media. Well, true media. What would true media be? Is it the flea? Is she true media? Nope, totally fake. Doesn't exist. Not true media. Is Lips true media? No, totally fake. Totally. Paint chips? Luthman? Nope, totally fake. How about Megan Fox? Nope. She's a fake journalist. That all those awards that she's won, and she's totally fake. Nope. Absolutely, Well, if they're fake and they're not real, then why are you worried about it? Why are you worried about it? Most recently, on June 14th, Jeremy Hale streamed a live broadcast to over 15,000 viewers, during which he repeatedly referenced myself and my wife, Leslie Ann Federigos. Now, what I find amazing here is she went and tried to create some privacy strikes against Nick Starro for saying Leslie Ann Federigos, showing who the person is that you're talking about. She gets upset whenever people call her Lips, although she's taken the name for herself. So you're not supposed to identify the person that you're talking about. You're supposed to say, this random person somewhere out there in the ether that can't be named because they're an idiot. And no wonder your channels are failing. No wonder your channels are failing. Because you don't know what you're doing. You don't know how any of this works. Yes, let's be more stupid. Let's be more stupid. Her latest price. Well, it's the same here. I mean, every time, Squid. I've got right now. My emails get flooded. Absolutely flooded with every time one of their privacy strikes fails, which they do constantly. Over and over and over and over and over again. They just keep failing. He also discussing the upcoming case management conference schedule for June 6, 2026. He just said there's a case management conference on June 6, 2026. And I can remember, because I went back as I was sort of wondering what exactly it was that he said. He said that he's going to be doing some work on putting the notes together for that status conference, that he's got it on Tuesday, but he's got another video that he's working on some other stuff, and he has to go back and he has to record and he has to get all of that thing set up. This is what she's trying to say, is that he said he was going to show up to court to record. That's not what he said. If you go back and you actually listen to what Jeremy said, you can go to those timestamps right here, and we are going to do that so you can understand what exactly it was that Jeremy was saying. Give me a second. I got to do something really quick. Hold on. This is going to make it a little bit easier on me, because I want to show you what exactly it is that she's trying to claim that he said, and it doesn't match up at all. It's absolutely horrible what she's trying to claim that he did. Just Jay, how are you doing? Oh my God, Jay. That reading that she did of her season desist is hilarious. Hilarious. If you haven't seen it, go check it out. J-Hip, that was the best reading. I am so glad you preserved that. That is the most glorious reading of anything that I have ever heard. I cried out loud. I cried absolutely out loud. That was so damn funny. So damn funny. And what I'm going to do is I'm going to write these down so you guys. So give me just a second, because I want to write these things down. It's at, let's see, 11:51, 12:21, and at 50 minutes, and at 54:40. Okay. 54:40. Got it. All right, I had to write these down because this is going to be really, really important. You want to really pay attention to this. If in case the Lips is out there listening. Oh, Lips, you're so idiot. Yes, epic. Big dirt lies. Big dirt lies. You've got. Hey, can you send that over to me, Jay? Really? Send it over to me, because I want to play that. That was so awesome. I want to play that. You gotta send that to me. Just email it to me. It just it is glorious. I will play that again. Shizzy doesn't read chat till 7 a.m. Yes, I do. Yes, I do. Damn it. I totally do. Totally read chat. You're at work now. You can send it to me. I'll do it tomorrow. It's fine. I do this every morning. Don't worry about it. Just make sure. Stay out of the left turns. Make it just a little bit slower in the left turns, so your wheels don't lose grip. You know, because that's how trains work. Absolutely. That's how trains work. Let me see here. We will share this screen just for you guys, because this is the absolute most hilarious shit. And when I saw this, I was like, oh my gosh, she's gotten this absolutely wrong in so many ways. Not just little ways, but some pretty damn big ways. And I want to make sure that I got this. All right. So what her claim is that he talked about doing something. I mean, that was what her claim was. He's doing this horrible thing. So here we go. And the first one is at about 12 minutes in. All right. So we'll fast forward it here to 2, 3, 4, 5, 6, 7, 8, 9, 10. And we'll start it a little bit early so you can understand what he's talking about. Okay. And I hope I set this up right. Let me restart this just to be sure that I got this, because sometimes I don't have the sound turned on. I want you guys to be able to hear this. All right. So here's what he was talking about. All right.
All right. We got some things we got to go over. First of all, we all know what happened in regards to federal bankruptcy court. So if you're not sure, you can go back and refer to a video that was released earlier this week. I think that was on Tuesday. I'm not really sure, but I think it was on Tuesday. That was released earlier this week. A lot of comments come through at times and say, oh man, you know, it would be so much easier to keep up with everything if you put dates in your videos.
As you can see, he's talking about videos.
Not only do I put a date in every single video in the description, but YouTube does, like in multiple places. And so I think what would help people if they learn how to navigate that, right?
Okay. Still talking about videos.
They navigate it and they can find dates in there. Well, you're going to see a video tomorrow, and it'll have a date of tomorrow in it, even though it was videoed, last week.
Has he said that he's going to be videotaping anywhere in court? No, I'm pretty sure he's talking about a video that's going to be released.
I think last week. So there's a safe. There's definitely a safe. All right, I'll give you that much. There's a safe, and it is full, and there's money in it. And I think this might help you as well, knowing that this came from the unit. Look at this, the heritage of the United States of America, the Midwest.
Miyagi, are you at work with Jay? I know Miyagi. Are you at work with Jay? I think an opportunity has been missed. Didn't one of them say they knew Vince McMahon? Can we say Tennessee Backyard Wrestling? Yeah. So right now, what he's talking about has nothing to do with the court case. Now we're at 11:35. He's talking about a recording, but he's talking about recording what's going on in a safe.
Not only the East and the West and the South. Not only
this is pretty cool.
Is this just a beautiful collection of collectible pennies now, but it's also a stamp collection.
All right.
And so that's literally just the beginning. Literally just the beginning. The first video will be released tomorrow. Tuesday morning at 8:30, we have court with lips and chips.
You saw what I'm talking. What just happened? All right, now I've already hit the very first part of this. I took it all the way back 11 minutes. 11:51. What was he talking about? See, he was talking about, and you can see right down here on the bottom. There's a little timestamp. It's 12:04 right now. Okay, 11:51. Talking about recordings. What was he talking about? a prior recording of a safe. That it hasn't been released yet, that he's going back and he has to do this recording. Okay. Now let's continue on because we're going to hit 12:21. Hey, by the way, Fleesa, you fucking mental midget, Lips, Chips, Paint Chips, Michael Vulpe, you fucking morons. You have to understand, this is what's called bring in the receipts. Idiots. Vet your shit.
Oh, wait, Chips bowed out. Interesting. But we have court tomorrow or Tuesday morning, but then part 2 will be released. And then part 3 should be coming soon as well. Probably Wednesday. Maybe not. It all depends. It all depends on what happens Tuesday morning during court with Lips and Chips.
So what is he talking about? That he is doing what he normally does, which takes notes and responds to it. And with his notes, he gives you sort of a breakdown of what happened. Gives you this nice little breakdown of what happened over the course of that hearing. Nowhere in here does he say he's doing any recording so far. I mean, we still haven't gotten there yet. All right. We're at 12:28. All right. And she's saying at 12:21 is whenever he mentions it. All right, let's continue on.
And so we'll see if part 2 gets released on Tuesday, or if I go, you know what, I'm just going to stop right here. I'm going to record and we're going to see what happens. Okay.
And we all understand what he's talking about. Good morning, Nick Starro. Has she still been striking you, Nick? Has she still been striking you? You're. By the way, Nick, you are allowed to talk about, her. You can say things. You can say things, Nick. My grandpa had a lamp made from pennies he welded together. That's crazy. That is absolutely crazy. How you doing, brother? I hope that you're having a wonderful morning. If you guys haven't seen Nick Starro, man, he's a fun guy. He's a fun guy. Yeah, don't let her get to you. Don't let her get to you. So all that time, and we're at 12:37. Nowhere did he say he was going to be in court recording. He talked about that he was going to be recording his. He's going to be making a recording of talking about what's going on in the case, what the status is in the case. That's what he said right there. I mean, all of that you heard, and we'll take it all the way from the beginning of this to 12. We'll take it down to 12:45. How's that? We'll start it at 10:29. Watch what he talks about. That's a bad freeze game. Look at that bad freeze game. There we go. Let me get this full screen and hopefully I can close that chat replay here. So this is what he says.
Sure, but I think it was on Tuesday. That was released earlier this week. A lot of comments come through at times and say, "Oh man, it would be so much easier to keep up with everything if you put dates in your videos." Not only do I put a date in every single video in the description, but YouTube does, like in multiple places. And so I think what would help people if they learn how to navigate that, right? They navigate it and they can find dates in there. Well, you're going to see a video tomorrow, and it'll have a date of tomorrow in it, even though it was videoed, last week. So there's a safe. There's definitely a safe.
Mm-hmm.
All right, I'll give you that much. There's a safe, and it is full. And there's
no
money
mention of her. We're 11 minutes.
I think
no mention. Talking about a safe.
This might help you as well, knowing that this came from the unit. Look at this, the heritage of the United States of America, the Midwest. Not only
good morning, Lisa.
The East and the West and the South. Not only is this just a beautiful collection of collectible pennies now, but it's also a stamp collection. And so
11:51.
That's literally just the beginning. The first video will be released tomorrow. Tuesday morning at 8:30, we have court with Lips and Chips. Oh,
saying this is what's coming up. They have a hearing coming up.
But we have court tomorrow or Tuesday morning, but then part 2 will be released. And then part 3 should be coming soon as well. Probably Wednesday. Maybe not. It all depends. It all depends on what happens Tuesday morning during court with Lips and Chips. And so we'll see if part 2 gets released on Tuesday, or if I go, you know what, I'm just going to stop right here. I'm going to record and we're going to see what happens. Okay. All right.
And you notice what the whole conversation was, talking about the recording of what was in the safe, talking about all of the things that are currently going on that may delay him from actually talking about, doing the recording to talk about the safe, to talk about what's in the safe. And she's trying to say that this is all about her. Well, let's fast forward this. Maybe here at about 50 minutes, maybe he's actually talking about what's going on. With them again. Yet again, let's see. We'll start it a little bit early so we have context here. All right. So this is at 48 minutes. Now she said at 50 minutes and all the way to 54:40. So this is probably about 10 minutes worth. And let's see what he's talking about here, because, according to her, he's talking about recording them in the courtroom. All right. That's what they're claiming. He's talking about recording them in a courtroom. Let's see. Let's look.
Lockerfox.com. Okay. Mm-hmm. So now we are going to go to, let me remove that. All right. We're going to go to lockerfox.com now.
So yeah, here we go.
And
lockerfox.com. Yeah.
There we go.
Let's see what we got.
I saw the 15-minute warning. We're good. Mm-hmm. We are going to do a collectible coin and money auction tonight. So I put Dawn's zip code in here already. I put 200 miles. For Dawn's sake, I'm just going to go ahead and put it 100 miles. I'm going to say Dawn's probably not going to be driving 200 miles for a storage unit. She's probably not as crazy as I am.
Okay.
We're just throwing that out there.
Coming on 49
so here's one
minutes.
In Akron. It ends in 1 day, 13 hours, 13 minutes. Okay. We already know it's above 160, which I would look at it, but you can look at everything. Look at everything and anything. Now here we get to see who the high bidders are on LockerFox, and this is kind of number 2. And we can see
49 minutes,
history.
Still coming.
Now bidding history can tell us who the big guns are, who's got the deep pockets, who's willing to pay. If we look at that actual bidding
49,
history.
40, 50.
What we're going to do right now is we're going to try and see what's inside here. You see this right here? That looks like a bingo marker to me. I like that because that tells 50 me older generation. Doesn't mean it's an absolute. Remember, we're profiling, trying to make money. There are a lot.
So far, I'm at her timestamp. There's still nothing there. Nothing so far talking about helping somebody out and how he does storage lockers and how he bids on them. I'm pretty sure that. He hasn't even mentioned her.
A lot of young people who like bingo as well. And by the way, let me state this as well. I find it really repulsing when I make a general statement about a particular person and then somebody makes a comment and goes, I'm offended because you said that. For example, last Sunday, toxic women. All right. Or a video, toxic women. Let's talk about toxic women. Fleesa, Lynette, Lips. But then I get a comment that goes, oh my goodness, I'm never watching you again. You called women toxic. I'm literally telling you who's toxic. Get over yourself. Let me pure and simply say that. Get over yourself. I don't know who you are. You don't know who I am. I'm obviously not talking about you. I'm talking about things that are happening in my life.
Yeah.
Now that we have that all gone, all right. So Gigi Grandma Gail just said, well, I'm old and I like bingo. When I make a blank.
I love you. It's awesome.
Blanket statement about a person. I'm referring to a person. All right. Even though JK says, hey, can you all just save your offensive feels? Man, I don't know what happened to this world and how everybody got so offended by everything. But by the way, when you're offended, it offends me. So Hope you can sleep well at night. All right, here we go. By
51
the way, I'm being
minutes, still
sarcastic
nothing.
as well. I know not everybody understands humor. Like I'm moving to Vietnam. That one didn't. That one people didn't get, did they? All right.
Nope.
So JBL. Here we have a big speaker right here. So that could be worth quite a bit of money if it's actually in there. What I would be looking at is to see, was it cut open? Was it not cut open? What's going on with it? I see bingo over here. I see shark
cards.
and oots.
All
These
right.
are potato chips.
Coming up on it. We're 52
And
minutes in. I still haven't heard
Don
anything.
the drum.
No, pretty sure.
All right, let's look at another picture. Let's go
All right,
scroll
we're looking
down.
at another picture.
I kind of blew these all up. I see
Nothing.
Gray Goose, Fragile. There we go. Mom stuff right there. All right. This
52
very well
minutes.
could be mom passed away and they put
52
everything
minutes.
in
Still
the
nothing?
storage unit because they didn't know what else to do. This looks like a guitar, head of a guitar. So this would be the head of the guitar and the pegs, the tuning
Could be.
pegs. To me, it does.
It could be a broken guitar stock too. I mean, there might be a headstock in there. There could be a guitar behind it, but it could just be a broken headstock. I've had those before.
And typically I'm doing this within mere moments, minutes, if not seconds, to where you train your eye to see what nobody else is seeing. All right. So we're scrolling down. To me, you know what this looks like? Trash, and more trash. If it looks like trash, it most likely is trash. Now, there are times where it's not trash and somebody makes it big, but that is so few and far between.
So we're at 53 minutes.
Kind of like this unit. I want to know what this guitar is. I want to know what's in mom's stuff. And I'm always looking for more boxes and more totes, because if I'm doing volume, if I'm doing math, if I start to think about square footage, what's in the boxes, the totes, and
53.
what's the probability of me making money? The more boxes, the more totes, the more probability of me actually making money. So I don't like all this spare space. It's not really full.
53
See what I'm
minutes.
saying?
Still nothing.
It's actually extremely
Storage
not full.
unit.
I also don't like these walls. I've bought from this facility before. These walls are fiberglass, and then you get fiberglass in everything, and then fiberglass gets on your skin, and I just don't like it. I do not like
53,
it. Okay.
59,
We're
54.
gonna look at-
All right,
we're
54,
gonna look
40.
at one more.
Still looking at
on
storage.
Locker Fox. Now, Locker Fox, depending on where you live,
Okay.
Locker Fox is big in some
Yeah,
areas
still
where
here.
Storage Treasures isn't, and Storage Treasures is bigger in other areas where Locker Fox isn't. But usually the big one is Storage Treasures.
54, 18.
and then
Still nothing.
lockerfox.com. All right, let's see what we need to see here. We're at $200. J49 is in. We can see everybody who's bidding.
54,
I wonder if
29,
that's Amber
54,
Hines,
30.
Amber Goose 13. That could. Oh, I wonder if that's JK J49. Peachy, Mo Money.
Yeah.
All right. So we know it ends at noon on Tuesday.
54,
That's when
40.
Portwood Lips and Chips ends as well. Although I'm not sure Chips is going to be there. All right, let's see what's in.
So that's what they're complaining about. And by the way, your timestamp is wrong. It's 54, 53 that you're complaining about. Now you have to understand, he goes, man, I wonder if he's going to be there. You're allowed to ask those kinds of questions. Are these people actually going to show up to court? That's their big complaint. That right there is her big monstrous complaint of how he was talking about her and only her. Oh, it was all about lips and chips. Relevant remarks. The relevant remarks. That's what she's complaining about. These are the relevant remarks. Oh my God, look at how horrible this guy is. And look what he did. Nothing. Attached are the full video transcripts. We didn't need it. We just watched it right there. What he talked about. Well, according to her, these online broadcasts do not serve any legitimate journalistic purpose and are intended solely for entertainment and profit. That broadcast, absolutely. It was about boosting up his channel. Pretty straightforward. I'm pretty sure that, yeah, that's what you do. There's a reason why you do YouTube, and it's not to sit there and suffer these fools. It's to, make money. If you're doing YouTube to be free, to say, hey, I'm just gonna do this free, then don't monetize your channel. Just Don't monetize it, and don't even talk about monetization. Don't even have a link to, any sort of way for people to donate. Don't tell people to give it a thumbs up. Don't do any of that. If you don't want to make any money on YouTube, then, just have something like Stupid Dave, which doesn't make money on YouTube unless you're, getting somebody from the UK to send you, a few $1,000s for, equipment that you suck at using. You can always do that. Often at the expense and dignity of the court and the privacy and safety of parties involved, plaintiff's conduct is concluded publishing misleading information about court proceedings and mocking opposing counsel. You can do that. You can mock them endlessly. Yeah. Or even judicial officers. Given the circumstances, in light of our pending motion for protective order, we respectfully object to any recording or broadcast of the case management conference scheduled for June 16th, 2026. Well, that would be impossible. I mean, if I'm not mistaken, you're able to not record unless the court allows you to. This objection is made to, and you can actually write them down and take notes because, well, it would be stupid if you didn't. You could also have a court reporter there. This objection is made to further prevent harassment, misrepresentation, exploitation of these proceedings on social media and YouTube. Well, what would be awesome is if it was recorded so you could see everything that was being said. It's the same way with the Flea's, privacy complaints that she wanted to throw out there that, got, what was it, 15 videos that I said, you know what, screw it. I'm going to pull them down. I'm just going to re-upload them. So she's going to have to go through each one of those and resubmit a new privacy complaint if she wants to get those taken down. Yeah, those will all be coming back up. And they're also, you can find them on Rumble. You can find them on Rumble. Every 1,000 views I get on the video, the prior video, I will release a new one. And every time a new one comes up, it gets 1,000 views, I'll release another one. We respectfully object to any recordings broadcast of the case management conference scheduled for June 16th, any other official, and that's today. This objection is made to prevent further harassment, misrepresentation. We thank the court for its attention and to this matter and stand ready to provide any additional information or clarification to the court may require. And signed digitally by Michael? I could have sworn that this was Lips because, there's certain tells and certain giveaways. Well, Randy responded. Randy did respond. Right here. Plaintiff's response in opposition to defendant's improper request for affirmative relief and motion to strike. Because he was CC'd on this. And he had to file something in the court, which would be proper. Well, Jeremy, George, Megan, Tug, they respectfully submit this response opposition to the document filed by Michael, or as we like to call him, Dorito Chips, on June 15, 2026, styled as notice of email to Judge Tanya Davis. Through this filing, defendant seeks to affirmation relief from the court, specifically an order prohibiting any recording or broadcasting of the case management conference scheduled for today, except by an official court reporter. Defendant's filing is procedurally defective in every material respect and should be stricken, or alternatively, the relief requested should be denied. The document violates Florida Rules of Civil Procedure 1.202, which became effective January 1st, 2025, and requires parties to confer in good faith before filing non-dispositive motions and to include a certificate of conferral with such motions. Defendant filing contains no certificate of conferral whatsoever, provides no evidence of any attempt to confer with plaintiffs before filing, and demonstrates complete disregard for this mandatory procedural requirement. Beyond Rule 1.202 violation, defendant's filing suffers from multiple additional fatal defects. First, it is improperly captioned as a notice rather than a motion, despite seeking affirmative relief from this court. Second, the actual request for relief appears not in a properly formatted motion, but in an attached email letter beginning, "Dear Judge Wilson," and containing no legal citations or structured legal argument. And third, and most troubling, the filing reveals that defendants sent this email directly to Judge Wilson before filing it with the court and serving it on plaintiffs. Another clear violation of Florida's strict prohibition on ex parte communications with judges concerning pending proceedings. It is irrelevant and material if opposing party was included on the email exchange requesting affirmation relief on a document that was not filed with the court and on such short notice. Most significantly, defendant Michael or whatever his name is, Federigos, is a licensed Florida attorney with a bar number. He's charged with knowledge of proper motion practice, the rules of civil procedure, and the prohibition on ex parte communications. His deliberate circumvention of these fundamental procedural requirements demonstrates either a fundamental misunderstanding of Florida procedure, or it being an idiot, or a calculated attempt to gain tactical advantage through procedural impropriety. Neither justifies granting relief based on this defective filing. Now, plaintiffs respectfully request that the court strike defendant's filing as a nullity, or in the alternative, deny the requested relief due to defendant's failure to comply with the rules, his improper ex parte communication with the court, and his failure to present a properly formatted motion with supporting legal authority. Plaintiffs received notice of defendant's request for relief less than 24 hours before the case management conference that is subject of the requested relief, providing insufficient time to research the legal issues, consult with clients, and prepare a comprehensive written response. Each of these violations independently warrants striking the filing or denying relief. Sorry, had a cough. Collectively, they demonstrate a wholesale disregard for the procedural rules that govern civil litigation in Florida and require that this court decline to consider defendant's request. Rule 1.202A imposes a clear duty before filing a non-dispositive motion. The movant must confer with opposing counsel in a good faith effort to resolve the issues raised in the motion. This conferral requirement is not optional or discretionary. It is mandatory, as evidenced by the rules use of the word must. In addition to the duty to confer, Rule 1.20 requires the movant to include certificate of conferral at the end of the motion and above the signature block. The certificate must be in substantially the following form. And this is what Randy talked about whenever he was having to school Deuce on proper procedure of filing motions and such, and why there was so many times that, he was just like, Your Honor, I keep having to tell him that he's doing things inappropriately and just absolutely wrong. And I'm having to correct him constantly. Some of Randy's frustration, I'm sure. And this is the following form. I certify prior to filing this motion, I discuss the relief requested in this motion by, and then the method of communication, the date, with the opposing party, and the opposing party disagrees or agrees on the resolution of all or part of the motion, or the opposing party did not respond, describing with particularity all of the efforts undertaken to accomplish dialogue with the opposing party prior to filing the motion. Alternatively, if conferral is not required under the rule, certificate must state that I certify that conferral prior to filing this is not required under this rule. Defendant's filing constitutes a non-dispositive motion. subject to Rule 1.202's requirements, despite being improperly styled as a notice. Florida courts emphasize substance over form when evaluating pleadings and motions. When a document is properly titled, the court should focus on the substance of the document based on its content. The substance of defendant's filing is a request for affirmative relief from the court, specifically an order prohibiting any recording or broadcasting the case management conference schedule for June 16th, other than by an official court reporter. This request seeks a protective order or restriction on conduct, which is clearly a non-dispositive motion. A non-dispositive motion is one that does not dispose of the entire case or any claim within it. The defendant's request for restrictions on recording does not seek dismissal of claims, summary judgment, or any other form of final disposition. The Florida Rules of Civil Procedure provides that motions must be made in writing unless made during a hearing or trial, must state with particularity the grounds for it, and must set forth the relief or order sought. Defendant's filing seeks specific relief and order prohibiting recording, and therefore functions as a motion regardless of its improper styling as a notice. Because defendant's filing seeks non-dispositive relief from the court, it falls squarely within the scope of Rule 1.202's conferral and requirements of certification. Defendant's filing demonstrates the complete and total failure to comply with those rules, mandatory requirements. The record establishes the following violations. First, that it contains no conferral whatsoever, requires a certificate appear at the end of the motion above the signature block. Defendant's filing does no such certificate in any form. Second, there's no evidence anywhere in the filing that the defendant conferred with plaintiffs or their counselor before filing this bullshit request or sending his email to the judge. The filing provides no statement that conferral was attempted, no description of any efforts to communicate with opposing counsel, and no explanation for why conferral did not occur. Third, there is no indication that the defendant made any attempt to resolve his concerns about recording through discussion with opposing counsel. The purpose of Rule 1.20 is to require parties to confer in good faith effort to resolve issues before burdening the court with another frivolous motion. Defendant's failure to confer deprived plaintiffs of any opportunity to potentially resolve the issue without court involvement. In other words, she could have emailed Randy and said, I don't want to have any sort of recording. I don't want to have any sort of recording except for outside of a court reporter for this. And Randy could say, well, I'm going to record it and I disagree with it. And then she could say, oh, well, I'm going to file a motion. If you don't agree to this, I'm going to file a motion to have all recording devices off in the court. And you would have done this, months ago. And then he could have come back and said, okay, well, go ahead and file it and we'll file an objection. Here's what our objection is. Or he could have said, hey, we'll absolutely agree. Yeah, it could have been done in an email. Could have been done in an email, and then she could have listed a conferral on it. He would have said, yeah, I absolutely agree with it. And then whenever the document would have come in, it would have said, I already contacted, and none of this is going to be recorded except for by a court reporter. Simple. But instead, she had to do this bullshit where now he has to file a motion on this, a motion on this to basically get this handled. This last-minute filing demonstrates a complete disregard for the conferral process and the rules that requires it. No exception in the rule applies to excuse their noncompliance. Defendant cannot claim ignorance of the rule as a licensed attorney who is charged with knowledge of all procedural rules governing civil practice. The rule has been in effect since January 1st of 2025, providing ample time for all members of the Florida Bar to become familiar with its requirements. That rule's requirements are mandatory, not discretionary. Courts strictly enforce conferral requirements to ensure that parties make good faith efforts to resolve disputes before seeking court's intervention. When parties fail to confer before filing motions, they burden the court with disputes that might have been resolved through a simple communication between counsel. Florida courts have the authority to impose sanctions for these violations of procedural rules. After notice on its own motion, the court may impose sanctions for any violation of these rules or for the filing of any proceeding, motion, brief, or other document that is frivolous or in bad faith. Such sanctions may include reprimand, contempt, striking of briefs or pleadings, dismissal of proceedings, costs, attorney's fees, or other sanctions. Based on the defendant's complete failure to comply with Florida Rule of Civil Procedure 1.202's mandatory conferral and certification requirements, plaintiffs respectfully request that the court strike their filing in its entirety, or in the alternative, deny the requested relief. The violation is clear and unambiguous. The filing contains no certificate, provides no evidence of any attempt and to confer, and demonstrates complete disregard for this mandatory procedural requirement. Their filing is fatally defective and must be stricken as a legal nullity. The document is captioned as a notice of email to Judge Tanya Davis when it actually seeks affirmation relief from this court. The request for relief appears not in a properly formatted motion and in an attached email. This informal email contains no legal citation, no structured legal argument, none of the elements required for a motion. Florida law draws a fundamental distinction between notices and motions. A notice is a procedural document that informs parties of actions taken or scheduled events, such as a notice of a hearing, a notice of appearance. A motion, by contrast, is a formal request asking the court to issue an order granting specific relief. So there's your little schooling. When a party seeks affirmative relief from the court, they require that party file a motion, not a notice. It also establishes that motions must be made in writing unless made during a hearing or trial. State with particularity the grounds for the relief sought and must set forth the relief or order sought. This requirement ensures that courts and opposing parties clearly understand what relief is being requested and on what legal basis. The distinction between notices and motions is not merely semantic. It reflects a different procedural function that these documents serve. A notice provides information, a motion requests action. The party cannot circumvent the requirements for motions by styling a request for relief as a notice. Here, defendant seeks a court order prohibiting certain conduct at a scheduling conference. This is quintessentially a request for relief, must be presented through proper motion, not disguised as a notice of email. Their email sought a court order prohibiting recording of the case, a request for substantive relief requiring judicial action. The email contained extensive factual allegations about YouTube activities that were wrong. Their conduct as improper, YouTube transcripts. Oh, there was a YouTube transcript of their conduct as improper, YouTube transcripts, and argument about why relief should be granted. The ex parte communication violation in this case is particularly egregious because it was committed by a licensed Florida attorney who is charged with knowledge of that prohibition. He cannot claim ignorance of the rules governing attorney conduct and ex parte communications. Now, the timing of the communication one day before a hearing maximized the prejudice to plaintiffs. By sending his email to the judge immediately before the case management conference, defendant ensured that Judge Wilson would receive this characterization of events and his arguments at a time when they would most likely influence the judge's perception while denying plaintiffs any meaningful opportunity to respond. Because if he would have responded to it, he would have pointed out that that's not what it says that it says. The remedy for striking a filing or denying relief serves a very important purpose. First, it protects the integrity of judicial process by ensuring parties cannot gain advantage through improper conduct. And that's totally what she was trying to do, or he was trying to do. It's really hard to determine who is actually writing because they live in the same household. And she says that she files things on his behalf all the time. So, I mean, is she trying to get him fired from, being an attorney, trying to get sanctions against him? Yeah, there is a hearing today. Yeah, Malin, there is absolutely a hearing today. and they're probably waking up and, drinking their first cup of coffee, getting ready to go plead that. There's actually 2 hearings today, Melanie. There's 2 hearings today. Believe it or not, there's another hearing going on that some of the parties might be involved in. I wonder how they're going to be able to make it to both of them. That'll be interesting. Who denied notice an opportunity to respond? Third, it deters future violations by making clear that improper conduct will not be tolerated. The appropriate remedy is to strike defendant's filing or deny any relief sought therein. Allowing defendant to benefit from this improper conduct would undermine the integrity of the judicial process and condone serious violations of procedural rules, ethical obligations. The remedy is particularly appropriate here because defendant is a licensed attorney who is charged with that knowledge and proper motion practice. For all the foregoing reasons, all of the plaintiffs respectfully request that this court enter an order striking the filing caption notice of email to judge 6/15/2026 as a nullity, that it fails to comply with Florida Rule of Civil Procedure. In the alternative, denying any and all relief requested to the defendant's filing due to complete failure to comply with Florida rules. Improper caption and format that fails to satisfy the requirements for motions under Florida law. Failure to cite any legal authority supporting the relief, and inadequate notice to plaintiffs and insufficient opportunity to respond. 3, ordering that if defendant wishes to seek similar relief for future proceedings, he must file a properly formatted motion that complies with the rules. Properly captioned, contains legal citations, case law, provides adequate notice and opportunity for plaintiffs to respond, does not involve any premature communications with the court. 4, awarding plaintiffs the reasonable costs and attorney's fees incurred in responding to this bullshit, if appropriate and under applicable law, and also anything granting such other and further relief as this court deems just and proper. And this was submitted on June 15th. By the Brandel shock it. I think that's pretty solid, don't you agree? That's pretty damn solid writing there. Tug. Wow, well. Someone is in deep shit. Yeah. What's going to be interesting is that they should be able to make it to both because of the time difference between the two of them. It's in an hour. Yeah. So this particular one, whenever it happens, it's going to be happening. And one of these conferences usually is only, 10, 15 minutes, maybe a half hour at the most. Normally that's what it would take, because you're basically just doing a pretty straightforward, just, get like, a case management conference is just sort of cleaning up the docket a little bit. I mean, really, that's what a case management conference does. It's just pretty minimal amount of things. They say, well, we've got this is what we're looking at, this is what we're doing. And then the judge sort of sets the rules of, well, I need to have this from you. I need to have this done. I need to do this. And this needs to be handled. And they'll set aside certain times to handle certain parts of the case. They won't hear any of what's going on. If there's any motions or anything like that, any motions, pleadings, she's going to say, this brief is done at this point in time. I need to have your response in no later than 7 days or 14 days or 21 days or 30 days. And then you'll have a chance to respond to it. And basically just lining out how the case is going to proceed. That's why they call it a case management conference. Just like, we're going to do this first, then we got to have this, then we got to have this, we got to have this, and this needs to be responded to. And then they'll ask if there's anything that the court that the court can do to, get this moving along, such as, trying to figure out when the judge needs to sign certain documents or when certain pleadings have to be done. And it's going to go pretty quick. I mean, the judge isn't going to hear any of the merits of the case or any crap like that. I mean, they might say, hey, we don't want to have recording equipment. And the judge will say, well, make a motion on it and I'll rule on it. and then you'll have a certain amount of time to respond to it. And she'll sort of assign different, lawyers to do different things. It's a case management conference. It's not a big deal. The other one, not so much. The other hearing that's going to happen today is much more intricate, and I can't wait to see the outcome of that. And probably tomorrow I'll have some other stuff that I'm going to be talking about that's not related to some of this at all. But it is. I mean, it's got some of the same players, but that's going to be really interesting. I'm also working on doing some really, really cool stuff with Mo this evening. If you weren't here last night to see what we were doing, well, there's even more. And we've got Mo, which I will be sending you guys over to here shortly, probably in the next 15 minutes or so. That's that we've been sort of looking at the Sharilla, documents, and there's so much more. I believe that Rosalind's also looking at some other stuff. She's got a different way that she's looking at, which is going to be really cool also. Let's have some fun and read your super chat. I don't see a super chat. Is there a super chat? Is there a super chat? I didn't see one. Sometimes that happens. Sometimes those super chats come in and I don't actually see them because they don't light up over here. Let me see. Oh, yeah. Oh, here we go. There it is. A $20 super chat. I mean, Clark Stark, eat me out. That's so bad. You are so bad, Malin. So bad. That did kill me. That did kill me. Oh my God. There are a few. I don't see them. See, this is annoying. Let me go in here. Look on the YouTube side. I'll have to look on the YouTube side. If there's super chats, they're coming in and I'm not seeing them. Damn it. Let me double check. Let me see. Is there any? I'm not seeing any. Are they coming in on a Rumble side? It is bad. I don't know. What happened. Tell me who it was that put in a super chat. And I'll pull it up. Let me see. Oh, Shizzy, do tell, please. Let me see. I'm looking. I'm scrolling back up through here. Now, if there were a super sticker, they don't show up the same way. I'm arrived at it. I'm looking. Morning. Nope. I see slow moving giant. Good to see you, slow moving giant. Oh, never. Where in the hell is that wall? I'm confused. Maybe I'm missing something here. Squid. Nope. I don't see any. And I'm scrolling up through here. If I missed them, I do apologize. Normally I try to catch them, but for whatever reason, yeah, Malin, that's the only one that I'm seeing is yours. Unless there was some more before then that came in or after. I'm not seeing them. My eyes are getting blurry. Trying to look through all of this. You guys type a lot. I love it. Good morning. And I'm looking. Bonjour. Okay. Hello, faves. Dang, lawyer right in a clean motion. Yeah, that does happen. I've heard rumors that he's going through a divorce. I don't think that's true. I don't know. Good morning, Laura. Good morning, Starzy. Good to see you. See Spawn Trooper. No, I'm arrived. I'm looking. No. Morning. So in a nutshell, lips is effect. Simples. Yeah, pretty much. Okay, I'm still not seeing any. Maybe I just missed something here. Hello all. Terry Bear, good to see you. Glad you can make it in here. And I'm looking. I'm still scrolling down. I'm looking for because I'm slow. There are two. Where are two? There are a few. You guys are saying there's a few and there's two. I'm totally missing these. I don't see them. Now, see, I see this one. See, here's a super chat. This is what a super chat that shows up as blue on my screen. Like seriously. They have a very specific way of showing up, and I don't see too many. I mean, I go all the way up to the very top and scroll down, and then Mountain is the first one I see. Like strange little I wanted to say that I almost said the wrong word there. Strange little badgers has been celebrated for 4 months, and then I come down and I scroll down, and then I've got yours. So if there's anything after that, I'm just not seeing them. Like they usually have a very specific color to it. I'm looking. I'm just not seeing. But oh, there we go. Like. Yeah, see, right there. Best chat. Got that one. I'm scrolling down. Man, you guys are awesome in the morning. You just constantly keep me going. I'm looking. Nothing's lighting up like you know. I'm looking for glowies here. Okay. Yeah. See. Okay. Nothing. See. I'm slow. You have to remember I do this by myself. I don't have a whole team. I don't have a whole team of people like working for me. They're similar. Yeah, they're similar. I got it. Mr. Coop, the computer good today? Oh God, yeah. Mr. Coop, did you get your issue fixed? Because that was bad yesterday. That was really bad. I was lurking in his chat and working at the same time. Oh my gosh, it was hilarious. It was so much fun watching him just like panic whenever his computer, like he lost power and everything just went poof. Everybody's like, what happened, Mr. Coop? He's like, I'm here. Don't you go away. Don't you leave. Oh my gosh. Yeah. I mean, yeah, I got those two. That was okay. That was all three. See, I'm special. I can get 3 super chats, which is 2 more than the fleas can get. It drives them nuts. Yes, you did. Wow. We sure Fleece ain't in here taking these super chats for herself. It's her MO. She's got to take them all. Take all the super chats because that's what you got to do. Oh my gosh. Let me see. I want to see if we've got anything else. I'm not seeing anything there. I was looking to see if something else was happening there. And yeah, I mean, that's pretty much it for what's going on. It really is. Oh, they went to Clark. Yeah. Clark is always in there stealing things from me. And you didn't even have to yell at chat to get them. I know, isn't it weird? Like I was so surprised whenever she was very, very upset that maybe because I got more super chats for her birthday than she did. And she like 3 days later, she was going, no, I still haven't hit my goal for my birthday. You guys hit the super chats and send me more money. I was like, wow, you're really bad at this, aren't you? Like really bad at it. Oh, did Jay stream site my he always does. He always takes my super chats. He doesn't like me. You know that, right? He constantly is, looking for my Cheerios and leaving the little gifts, he calls them. Yeah. Damn Jay. But that's all right. We got him covered. We get him back. Sometimes we lay pennies on the train tracks. Mm-hmm. And I know that'll get him. Blame Jay for the super chat debacle. Absolutely. I like Shizzy. No, you don't. Stop lying. I'm going to leave more pennies on the train tracks just for you. Just for you. I'm going to put them out there because I know that will derail you. Gotta derail Jay. Don't talk about derailments on my stream. Megan was complaining about you streaming last night. Yeah, I know she does that. That's okay. I got something for her. I'll be streaming again tonight. Except I'll be on Mo's channel. Yeah, we'll be over on Mo's at 7:00 tonight. If you're not subbed up to Mo, well, you'll get a chance to whenever I send you guys over there. Look, I got 225 of you wonderful people in here. You know, all you got to do is really hit that thumbs up. Make it feel good. Not after your Ohio incident. Well, that wasn't entirely your fault. I mean, they did pay you a good amount of money to, you know, to make sure that train was going in the right direction. Absolutely. Yeah, absolutely. He's a clown loser. Total clown loser. Oh, is that true, French Psycho? Beware, it starts with you Cheerios and then he pops your sherry. Mm-hmm. I believe it. Whoa, wow. What did you do this time, Just Jay? God, not enough bail money to get you out. There never is enough bail money to get him out. But I will tell you, over here, we are raising money to get his bail. And the more that we get, the more that we can spend on it. Actually, that's probably a bad grift. Because everybody would go, no, please don't get him out. Don't get him out. That's a bad grift. No, that's a really bad idea. That's an absolute bad grift. No, we're raising money to keep him in jail. There you go. That's a better one, because if I raise it to get him out of jail, nobody's going to want to donate, and that's not going to work. Nobody's going to want to super chat if I'm saying that I'm going to get him out of jail with that. So you have to say, we will make sure that we do it to keep him in jail. We'll file more frivolous litigation for him. There we go. There we go. My J-Hip tax. Thundertaker, here's my J-Hip tax. Now, see, that's the way we do it. That's how we keep him in jail. The more that we do, the more that we raise over here, the more we can keep him in jail. Yes, that's what we need. The ecosystem fail money. Oh, yes. I'm going to ask someone to create a Blame Just J-Hip. There, yeah, see. Well, you've got people in here that'll do this. You got people in here that might just create those Blame J-Hip. Rehab, maybe? No, we don't want him rehabbed. No, we like to keep him slow and ADA protected. No, that's the best way to keep Jay slow and ADA protected, because it provides the most entertainment. I mean, if you take away that ADA protection, you take away the entertainment. We can't have that. You make very little money, according to Super Dave. It's sad. Well, it is sad. It is so low. You know what I mean? But you need to raise the bar higher, Jay. Raise the bar higher so that way you can walk under it. That's how you do it. That's how I found out. You know, you raise the bar so high that you're forced to walk under it. Instead of Blame Jerry, it's Play Jay. It should be. It should be. Absolutely. Sounds like Star. I hope you're enjoying it. All right, everyone, we're sending you over to go see the lovely Mo in the deep end. Thank you guys for being here today. And I will be back again tomorrow with more shenanigans and probably some more court documents, or who knows what's going to happen. I've got so many things coming up. You should be prepared for the best. I will see you guys tomorrow. Peace.
I thought I was the only mentally challenged one here.
Ooh, baby. Morning's here again. So let's do this, sugar. And no cream. Wake up slow, take that first sip. Shizzy's got 'em slipping, losing their grip. His moves so smooth to start your day. What you gonna do? Oh, you know the way. You know Papa don't flinch, don't blink. Ooh, baby, he's sharper than you think. Morning Whiz, take it in. Shizzy's got a whole new spin. Fools keep falling, truth's on fire. Papa not just just lit the pyre. Oh no, they tried to come for him. Look at those fools looking so dim. They poke, they scratch, they beg, they plead, but I'm right here, waiting for my daddy to lead. Pour it black, shake off the night, Shizzy's tease and get me going just right. Morning whiz, start the show, sip it slow, let it flow. Fools are crying, game's been set. Ooh, baby, they ain't seen nothing yet. Now that's a morning sugar. Coffee's hot and burning, and Shizzy Daddy, oh, he's just getting started. Come on, Daddy, get me some of that something.
Oh my god, Shizzy breaks Larry. Shizzy broke Larry.